Hello, I'm Open Government Assistant Attorney General Nancy Crear, Washington State Office of the Attorney General. This video provides public records training and general information on exemptions from disclosure. This video supplements our office's online training materials covering the Public Records Act basics. We assume that viewers of this video have already accessed other materials covering the PRA basics. This training is consistent with the office's advisory PRA model rules. This video was prepared in early 2019. The legislature can amend the public records laws in the future. The courts can also interpret the laws. Consequently, and as a reminder, there may be developments in the law after this video was prepared. Several updates on the law are often posted in materials on the Attorney General's Office website, Open Government Training page. The website also has an Open Government Resource Manual, which is an online manual discussing open government laws, including the PRA's exemptions. The office's website is at www.atg.wa.gov. This training video contains 6 segments where we will review 1. PRA definition of public record. 2. What is an exemption? 3. Procedures often used for an agency to apply an exemption to a public record. 4. Examples of some exemptions common to many agencies. 5. How a requester can challenge an agency's decision to apply an exemption. And 6. Other resources. Let's begin. In this first segment, we will cover a few preliminary matters, including a brief recap of the PRA. Back in 1972, when the people enacted Washington's PRA requiring disclosure of public agency records, there were approximately 10 reasons specified in the PRA, plus presumably reasons in other laws, as to why a public agency could withhold a record or part of a record. We called those reasons to withhold exemptions. At that time, most public agency records were paper. Today, there are more than 500 exemptions located in both the PRA as well as other state laws. In addition, some federal laws designate some information as confidential and non-disclosable. And today, we have both paper and electronic records. If a record satisfies the PRA definition of public record, a public agency must provide it in response to a PRA request. A public record includes any writing containing information relating to the conduct of government or the performance of any governmental or proprietary function, prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. If there is information that is exempt from disclosure in a public record, the rule still is, as it was 45 years ago, that only the exempt material can be withheld. While sometimes an agency can withhold an entire record or class of records on a categorical basis, most of the time, exempt information is redacted in a record, and all the non-exempt information is disclosed. An exemption is authority in law for a public agency to withhold from disclosure specified information in a public record. That is, the information is exempt from public release. Many of these exemptions are in state law, in either the PRA or other state laws outside the PRA. Some are in federal law. Sometimes a court order prohibits disclosure of certain information or records. The exemption statutes often use phrases such as, the following information is exempt from disclosure, or is confidential, or is exempt from public inspection and copying, or an agency shall not release particular information or records. In state law, the exemptions are located in both the PRA part of the code, which is Chapter 42.56 RCW, as well as many other chapters of the code. The state legislature may amend or add new exemptions in the state code. Many court decisions also give guidance on how to read and apply a particular exemption. In this segment, we are going to talk about the procedures an agency often uses to apply an exemption to a public record. This process occurs after an agency receives a request and searches for and gathers responsive record or records. We are calling these procedural steps the 4 R's. Review, research, redact or withhold, and report. The first step is for an agency to review responsive records to determine if there is possibly exempt material. Depending upon the nature of those records, the agency will be looking at whether the records may contain, for example, protected healthcare information, information protected by the attorney-client privilege, social security numbers, information about a pending criminal investigation, or home addresses of public employees, to name just a few areas of exemptions. Next, the agency will research whether an exemption applies. The PRA requires exemptions to be read narrowly to promote the public policy of disclosure. A record or portion of a record must fit squarely within an exemption in order to be withheld. Otherwise, the withholding is invalid. An exemption will not be inferred or presumed. Therefore, an agency needs to understand what specific exemption laws may apply to its records. For informational purposes, each agency is required to publish and maintain a current list containing every law, other than those in the PRA, that the agency believes exempts or prohibits disclosure of specific informational records of the agency. An agency's failure to list an exemption does not affect the efficacy of any exemption. That is, an agency can still rely on an exemption, even if it is not on this list. In addition, some exemptions are permissive, meaning an agency can choose to use them or not. Some exemptions, however, mandate that agencies not disclose specified information. An example of a permissive exemption could be the exemption for certain deliberative process and preliminary drafts, as provided in RCW 42.56.280. While an agency could assert the exemption as detailed in that statute, an agency might choose not to and instead release the information. We will talk more about that exemption in a few minutes. In contrast, certain child welfare records are made confidential and exempt under RCW 13.50.100. Those records can be disclosed only to the individuals authorized under that statute. When an agency is determining if an exemption is permissive or mandatory, it will first need to look at the language of the statute, then to any court decisions interpreting the exemption. Many times, the agency has already conducted this research for frequently requested types of records. In that case, it can often make a quick decision on whether an exemption applies to a particular record or piece of information in a record. Sometimes, however, an agency will need to research further. To illustrate, additional research may be necessary if certain statutory conditions must be present before non-disclosure or disclosure applies, and the agency needs to find out if the conditions exist. Or, for example, if there are new or recently amended laws that apply to the record, or if a new court decision explains the scope of a particular exemption, the agency may need to review those new laws or decisions. Or, if a court order prohibits disclosure or disclosure of certain records to certain persons, the agency will need to understand the scope of the order. Sometimes during this research step, the agency may see that there are persons named in records or to whom a record pertains. The PRA states that an agency may provide what is called third-party notice to such persons. This notice typically describes that there is a PRA request for such records, giving those persons a deadline by which to obtain a court order enjoining disclosure if those persons believe the records should not be disclosed. Often, an agency will need its legal counsel's help in these research and review steps, given the amount of law that it may need to consider. In the next step, the agency will determine if it must or may redact the information it believes is exempt in the record or records by removing it in a copy of the record, or whether the entire record is to be withheld. As mentioned, redaction is a common means of non-disclosing information in a record. That is because the PRA provides that, with certain exceptions, PRA exemptions are inapplicable to the extent that information, the disclosure of which would violate personal privacy or vital governmental interests, can be deleted from the specific record sought. An agency should make sure that it is redacting only the portions of the record that are exempt. So, for example, if part of an email contains information exempt as attorney-client privilege, but the rest of the email does not, an agency should redact only the exempt privilege information and must disclose the rest. An agency redacting a record may do that in any number of ways. If it is a paper record, for example, the agency might black out or white out the exempt information. If it is an electronic record, including a PDF copy of a paper record, The agency may have software that allows it to redact right on the electronic record copy, sometimes simultaneously affixing a code that corresponds with a particular exemption. If the record is a videotape, the agency may pixelate the exempt information by putting a dot over or scrambling the exempt image on a copy of the video. Finally, the agency must report in writing to the requester, citing the applicable exemption or exemptions, and briefly explaining the legal basis for redacting or withholding those records. The PRA does not dictate a particular format for the agency to provide this written explanation, and the method may vary from agency to agency. For instance, sometimes an agency will create an exemption log in a chart form with columns describing the record or records being redacted or withheld, citing the exemption permitting the redacting or withholding, and providing a brief explanation as to how the exemption applies to the record or records. Rather than a chart format, sometimes this written explanation is in a letter or email to the requester, providing that same information. And sometimes an agency provides a coded exemptions list that accompanies redacted documents, explaining the redactions and giving the legal citations. As a last note in this segment, it is possible that agencies are doing several of these 4 steps simultaneously, particularly for large requests. The PRA permits agencies to provide records in installments. As a result, an agency may be ready to produce one installment where the agency has completed the 4R steps for that installment. At the same time, it is still searching, gathering, and reviewing additional records to be produced in future installments. The exemptions used vary from agency to agency, depending upon the contents of the records at that agency. Some exemptions apply only to certain agencies. However, some exemptions are common to many agencies. In this segment, we are going to review 6 of the more common areas of exemptions. More information on these exemptions, and many others, is available in our office's Open Government Resource Manual on the website. Let's start with drafts. The PRA at RCW 42.56.280 states, preliminary drafts, notes, recommendations, and intra-agency memorandums in which opinions are expressed or policies formulated or recommended are exempt under this chapter, except that a specific record is not exempt when publicly cited by an agency in connection with any agency action. This exemption does not mean an agency can withhold a document or part of a document just because it's marked draft. Instead, the courts have said the purpose of this exemption limits its scope. Its purpose is to protect the give and take of deliberations necessary to formulation of agency policy. This exemption only protects records during a limited window of time while the action is pending, and the withheld records are no longer exempt after final action is taken. The courts have further said, in order to rely on this exemption, an agency must show that the records contain pre-decisional opinions or recommendations of subordinates expressed as part of a deliberative process, that disclosure would be injurious to the deliberative or consultative function of the process, that disclosure would inhibit the flow of recommendations, observations, and opinions, and finally that the materials covered by the exemption reflect policy recommendations and opinions, and not raw factual data on which a decision is based. It is not, however, required that documents be prepared by subordinates to be exempt. Another common exemption in the PRA is at RCW 42.56.290. That statute exempts records that are relevant to a controversy to which an agency is a party, but which records would not be available to another party under the rules of pretrial discovery for causes pending in the superior courts, are exempt from disclosure under this chapter. This provision exempts records related to a controversy involving the agency as a party in a lawsuit, where records would not be available to other parties under the court's rules. A controversy covered by this exemption includes threatened, actual, or completed litigation. Many agencies work with their attorneys if they are in or expecting litigation, and many attorneys also prepare records in anticipation of that activity. If an agency is a party to a controversy, the agency may withhold records that normally would be privileged under litigation discovery rules, commonly called the work product doctrine. To illustrate, a document is work product if an attorney prepares it in confidence and in anticipation of litigation, or it is prepared by or for a party's representative in anticipation of litigation. Work product can apply to completed, existing, or reasonably anticipated litigation. In addition, agencies often consult with their attorneys to obtain legal advice, and attorneys provide their client agencies legal advice. Sometimes that is in the context of litigation, sometimes it is not. Records protected by the attorney-client privilege are also exempt as confidential under the privilege statute at RCW 5.60.060, subsection 2. Also, many mediation communications are exempt as confidential under RCW 42.56.600, as well as the mediation statutes in Chapter 7.07 RCW. Turning to a different subject, the PRA at RCW 42.56.240 exempts several types of investigative, law enforcement, and crime victim records. Those exempt from disclosure include specific intelligence information and specific investigative records compiled by investigative, law enforcement, and penology agencies, and state agencies vested with the responsibility to discipline members of any profession, the non-disclosure of which is essential to effective law enforcement or for the protection of any person's right to privacy. The courts have held that specific investigative records are the result of an investigation focusing on a particular person or an investigation to ferret out criminal activity or to shed light on specific misconduct. The courts have also held that if a law enforcement agency maintains reports as part of a routine administrative procedure and not as a result of a specific complaint or allegation of misconduct, the reports are not investigative records within the terms of this exemption. The courts have ruled that pending investigative records of unsolved cases are categorically exempt, meaning they can be withheld in their entirety when the withholding is essential to effective law enforcement, but then only until the case is referred by the investigators to the lawyers for a charging decision. At that point, the investigative records are no longer categorically exempt and instead need to be reviewed on a record-by-record basis to determine any applicable exemptions. The exemption at RCW 42.56.240 goes on to list many other types of investigative and law enforcement information and records that can be withheld. Those include, for example, identities of crime victims or witnesses if disclosure would endanger any person's life, physical safety, or property, identities of minor child victims of sexual assault, information in gang databases, and many others. More recently, this statute also addresses the disclosure procedures for body-worn camera recordings. Turning to yet another topic, several exemptions apply to many records related to public employees. Several court decisions also discuss access to personnel-related records. One example of an exemption is at RCW 42.56.230. That statute exempts personal information in files maintained for employees, appointees, or elected officials of any public agency to the extent that disclosure would violate their right to privacy. The PRA describes a person's right to privacy is invaded or violated only if disclosure of information about the person, 1, would be highly offensive to a reasonable person, and 2, is not of legitimate concern to the public. Sometimes agencies investigate allegations of public employee misconduct, and records are created as part of that activity. The courts have held there is no privacy interest in substantiated misconduct. And in some situations, there may be no privacy right in allegations of unsubstantiated misconduct if disclosure of the allegations is not highly offensive. That is to say, while the determination of what is highly offensive is decided on a case-by-case basis, as a practical matter, the PRA is to be liberally construed in favor of disclosure, and the courts have set a high bar on what is considered highly offensive. An agency may give the affected employee or employees a notice of a PRA request, enabling them to go to court under RCW 42.56.540 to seek an injunction from disclosure. An agency might be required to give such notice under a particular labor contract. Courts have held that disclosure of an employee's performance evaluations, with no discussion of specific incidents of misconduct, is presumed to be highly offensive and of no legitimate concern to the public. Disclosure of this information between a public employee and supervisor normally serves no legitimate public interest and could impair the candidness of evaluations and employee morale if made public to anyone upon request. Another exemption relevant to public employment is RCW 42.56.250, subsection 2. This statute exempts applications for public employment, including names of applicants, resumes, and other related materials submitted with respect to an applicant. Another example is at RCW 42.56.250, subsection 4. This statute exempts the following information held in personnel records, public employment-related records, volunteer rosters, or included in any mailing list of employees or volunteers of any public agency. Residential addresses, residential telephone numbers, personal wireless telephone numbers, personal email addresses, social security numbers, driver's license numbers, identicard numbers, and emergency contact information of employees or volunteers of a public agency. This statute also exempts certain listed information of dependents of employees or volunteers of a public agency. Many other exemptions that may impact records concerning public employees are located in these and other statutes. A fuller discussion of exemptions applicable to public employment records is available in our office's online manual, along with a discussion of several court decisions. Additional topics covered in the manual include exemptions relevant to certain records of personnel investigations and complaints, employee whistleblower records, and others. Next, let's talk about valuable data and proprietary financial and commercial information that may be in agency records. Sometimes agencies create or receive information that has commercial or financial value. RCW 42.56.270, subsection 1, exempts valuable formula, designs, drawings, computer source code or object code, and research data obtained by any agency within 5 years of the request for disclosure, when disclosure would produce private gain and public loss. Research data, which is not limited to scientific or technical information, means facts or information collected for a specific purpose and derived from close study or from scholarly or scientific investigation or inquiry. Withholding the records is permitted only if disclosure would produce private gain and public loss. The courts have said the purpose of this exemption is to prevent the taking of potentially valuable intellectual property held by an agency. RCW 42.56.270 goes on to exempt other listed records containing proprietary, financial, and commercial information. In addition, other laws, such as the Washington Trade Secrets Act at Chapter 19.108 RCW, can exempt information from disclosure. Sometimes agencies receive records that the originator believes are trade secrets. Trade secrets are not categorically or automatically exempt, however. Such records may be enjoined from disclosure by a court only if disclosure would clearly not be in the public interest and would substantially and irreparably damage a person or a vital governmental interest. The burden in court rests upon the person seeking non-disclosure. This is another situation where an agency might give third-party notice, in this case to the affected business asserting a trade secret is contained in the records, in order to allow that business to go to court to seek an injunction restricting the agency from disclosing the records or information that contains trade secrets. Finally, another exemption that may be relevant to a number of public agencies is the confidentiality protections for healthcare records provided in both state and federal laws. As previously described, the Public Records Act provides that a record may be exempt under a PRA exemption or other law. The PRA at RCW 42.56.360 provides that certain specific healthcare-related information is exempt, and in addition, that Chapter 70.02 RCW, the State Healthcare Information Act, applies to public inspection and copying of healthcare information of patients. That state law is often called the HCIA. The HCIA establishes standards and obligations for government entities that serve as healthcare providers, facilities, or payers to protect records and to disclose as authorized. In addition, the federal healthcare law, the Health Insurance Portability and Accountability Act and its regulations, also known as the HIPAA Privacy Rule, regulates use and disclosure of an individual's health information by covered entities. The HCIA, in many aspects, mirrors the federal HIPAA. Therefore, if an agency has information related to an individual's health care, the agency will need to consider if any of the state or federal health care laws make such information confidential and exempt from disclosure in response to a PRA request. An agency will likely need to consider, for example, the nature of the healthcare-related information in the record, as well as the agency's role, such as whether it is a healthcare provider or other entity subject to the state or federal healthcare laws. Many other types of records contain information that is exempt under the PRA or other statutes. Those include, for example, many juvenile records, student records, financial information submitted to specific agencies, public assistance records, and many others. If a requester disagrees with an exemption cited by an agency, there are at least two, and for some agencies, three ways a requester can seek review. First, the requester can ask the agency to review the exemption again, essentially take a second look. This can be done at no charge to the requester. The PRA at RCW 42.56.520 requires agencies to establish mechanisms for the most prompt possible review of decisions denying inspection. Such review shall be deemed completed at the end of the second business day following the denial of inspection and shall constitute final action for the purposes of judicial review. An agency and a requester can mutually agree to a longer time for this second look, which is often necessary. The courts and our office have encouraged requesters and agencies to communicate on issues with respect to PRA requests. Second, if the agency denying the record is a state agency, the requester can ask the Attorney General's office to review the cited exemption and issue a non-binding opinion under RCW 42.56.530. This review is also at no cost to the requester. The office requires a final state agency decision prior to such a review. This option does not apply to local governments such as school boards, cities, counties, special purpose districts, and the like. This step of seeking review by our office is not required before a requester can go to court to challenge a state agency's application of an exemption. More information about this review is available on the office's website. Finally, a requester can seek judicial review under RCW 42.56.550 by filing a civil action in the Superior Court where the record is maintained. There's a 1-year statute of limitations. The burden of proof is on the agency to establish that the exemption was correctly applied. Court filing fees are required unless waived by the court. A court can award penalties and attorney's fees to a successful requester. More details are in RCW 42.56.550 and in court rules and decisions. Thank you for your interest in this Public Records Act topic where we discussed exemptions. For additional resources on the Public Records Act, see the office's website at www.atg.wa.gov. The office has PRA and training resources, including but not limited to videos such as this one, a manual, as well as the office's advisory PRA model rules in Chapter 44-14 WAC. As the Assistant Attorney General for Open Government, the Ombuds, I can also provide general information, technical assistance, and training. The office also has a Local Government Public Records Act consultant, who is a PRA resource for local government agencies on responding to records requests, seeking additional public and private resources for developing and updating technology information services, and mitigating liability and costs of compliance. We hope you found this video informative.